Next, I am going to explain about the kinds of companies. So, the Companies Act 1956 broadly classified companies into private companies and public companies and provides for regulatory environment on the basis of such classification. However, with the growth of the economy and increase in the complexity of business operation, the forms of corporate organization keep on changing. There is a need for the law to take into account the requirement of different kinds of companies that may exist and seek to provide common principle to which all kinds of companies may refer while devising their corporate governance structure. Rigid structures, unnecessary controls and regulations inhibit the task of taking initiative of the entrepreneurs. Private companies and small companies who do not generally go for public issues or deposits for their financial requirements but utilize the personal or in-house resources need to be given flexibility and freedom for operations and compliances at a low cost. Equally, public companies that accept capital from public need to be subjected to a more stringent regime of corporate governance. Uh, to enable a comprehensive framework for different forms of cooperative organizations, the company law should ensure multiple classification of companies. It should also enable smooth change over the companies from one type to another. And companies can be classified on the basis of size, on the basis of number of members, on the basis of control, and on the basis of liability, and on the basis of manner of access to capital. So companies can be divided into statutory companies, registered companies, public companies, and private companies. Statutory companies may be called as companies which are formed under the statute of Royal King or Queen of England. That is known as statutory companies. Registered companies means companies which are registered under the Companies Act 2013, that is known as registered companies. And on the basis of number of members, companies can be divided into public company, private company, and a one person company. And we can say that private companies, first we can discuss about the private companies represent a different set of relationship in terms of ownership, risk and reward as compared to public companies. Since private companies do not access capital market, they require less rigorous protection to their shareholders. They, however, represent an important organizational form for the conduct of business. Therefore, there is a case lighter for there is a case lighter for regulatory hangover over private companies. The existing law provides for certain relaxations of private to private companies on account of their nature. We are of the view that this approach should be continued and amplified where appropriate. While good corporate governance is equally where good corporate governance is equally do not lose the flexibility in conducting their business. In particular, the law should enable a private company to take any decision in it is in otherwise empowered to take without observing the formality of the act if the members of the company unanimously agree. A simplified circular resolution procedure should also be considered where unanimity is not possible. Since a dispute may also arise amongst the members of such companies, the cost of which may ruin the company, the regime for a private company should contain dispute resolution procedure simplified to the extent possible. So, next one is about public companies. Public companies are companies which are not private companies, and the next one is about one person company. One person company With the increasing use of information technology, the emergence of the service sector, it is termed as entrepreneurial capability of the people are given to the outlet for participating in economic activity, and a person who where there is only one director and one shareholders is known as one person company. These are all the different kinds of companies that we have to study. Thank you.